Hello class, this is Professor Smith, and this will be part 2 of the college level examination program's introductory business law course review. Today we'll be talking about our second unit referring to the history and sources of American law. The American legal system and procedures. Today we'll be talking about criminal law and civil law. Starting with that, criminal law is referred to as law that consists of laws that address crimes and the punishment of those crimes, and thus regulates the behavior of individuals to ensure that such behavior is consistent with society's conception of societally normal and moral appropriate behavior. Consider crimes against society, crimes against the state. Civil law refers to torts and contracts, represents law that law that regulates the relationship between parties. And these two law systems are really types of law are what we see a majority of American law consist of: criminal law and civil law. Courts help settle disputes alleged courts help settle disputes regarding alleged violations, criminal or civil law. Talking about the court system now, both federal courts and court systems have 3 levels of courts. This is starting with the trial court, moving on to the appellate court, and then the Supreme Court. Appellate court is also known as the appeals court. The federal trial system is referred to as the U.S. Federal District Court. There are 94 district courts throughout the U.S. and its territories, with at least one in each state. If a party appeals the district court's decision, they can bring the case into the appeals court or the appellate court, known as the Federal Circuit Court of Appeals or the Federal Court of Appeals. Pardon me. On that note, okay. The United States also has 12 district courts, and these are across the United States and group in multiple zones of the United States. If a party wants to appeal a decision of a federal circuit court, then they would want to seek to bring the case to the Supreme Court. The Supreme Court is a court that has the discretion to determine if it will review the decision of an appeal. When seeking an appeal to the Supreme Court, a party must petition the court for a writ of certiorari. 4 of the 9 justices must agree to the writ of certiorari for the appeal to be granted. If the Supreme Court renders a decision, it is final, given it is the highest court in the land. There are also specialized federal courts and state courts. Federal court-specific examples are the Federal Tax Court and the Federal Bankruptcy Court, while state-specific examples could be Family Court and Probate Court, as well as Small Claims Court. The functions of the court and procedures. Original jurisdiction refers to the first court to consider an action. Trial court is a court of original jurisdiction and is where trials occur, where parties present evidence to juries and or judges. The appellate court appellate jurisdiction refers to the power or jurisdiction of the appellate court, which has the power to review the decisions of lower courts. An example of that could be the Federal Circuit Court reviewing a federal district court's decision. The appellate jurisdiction is limited to reviewing, affirming, modifying, revising, or any therefore of decisions. Appeals courts do not conduct trials in this way. In general, appeals to decisions are granted and decisions are reversed if the lower court's decision reflects a clear abuse of discretion. On issues involving the interpretation of law, appellate courts do not defer to the lower court. As such, reverse decisions where it is improper and or unconstitutional in terms of its application of the law. If the appellate court reverses a decision or sets a decision aside, it may remand. And remand refers to the resending of a case to a lower court for a new trial. Supreme Courts have appellate jurisdiction, but only to review the decisions of the appellate court. The Supreme Court may remand back to the appellate. The Federal Supreme Court also has the power to review decisions from circuit courts as well as state Supreme Courts. The Constitution grants the Supreme Court jurisdiction to hear specific cases between 2 or more parties, as in 2 states or more, cases between the federal government and a state, cases involving officials of foreign countries, and cases by a state against a citizen of another state or country. Now, de novo is an entirely new decision that is made by the Supreme Court and does not defer to a lower court's decision. The federal rules of civil procedure regulate that the governing rules of procedure for filing a civil suit in federal court. States have their own rules, but generally they mirror the federal set of rules. Now, standing refers to the legal right to bring a suit, refers to the notion that a person who begins the suit must have imminently have a legally recognized injury, which is referred to as injury in fact. A party must have standing to bring a suit. Now, talking about the roles that people play in a suit, the plaintiff refers to the person who presents the suit. The defendant refers to the person who has been presented the suit, the person being sued in the situation. Now, pleadings refer to the documents parties file in connection to their lawsuit. A complaint could be filed with the trial court to set forth the basis of the lawsuit. This is filed by the plaintiff. Summons these are issued to the defendant, accompanied with a copy of the complaint, as it is a notice of the lawsuit that has been filed against the defendant. The defendant must respond to these summons. An answer refers to the defendant's response to the complaint. The defendant must admit or deny the allegation presented to them in the complaint within their answer. The defendant may arise that either they have a counterclaim, which is a claim that the defendant has against the plaintiff, or an affirmative defense. And then these are defenses that would prevent the plaintiff from holding the defendant liable. The defendant has the option to file 2 motions. One is a motion, a request for the court to take action, or 2, a demurrer, which is a motion to dismiss the case because the plaintiff's complaint does not establish a legal basis for remedy against the defendant. Pardon me. Now, Rule 12b of the federal rules allow for the defendant to make a motion based on either of these 6, a lack of subject matter jurisdiction, a lack of personal jurisdiction, a lack of venue, the failure to join necessary parties, lack of process, and lack of service of process. Okay, we are just about halfway done. Let's keep chugging through. Other than the lack of subject matter jurisdiction, these motions are referred to as Rule 12b-6 motions and must be made at the first available opportunity. A motion to strike refers to a desire to take out certain matters in the suit, and a motion for more definitive statement refers to the motion to want to clarify certain vague or ambiguous lines of text in the pleading or language specifically. A motion for a summary judgment, this can be filed by any time by any party and will be granted by a judge after they find that either 1, there is no genuine issue of material fact, and as a result, one party is entitled to prevail in the case as a matter of law. If the plaintiff's case is not dismissed, the parties will go to trial. Discovery refers to the ability to gain information concerning the other party and their witnesses. This can be done in the pre-trial phase. The judge may conduct a conference before the trial and guide parties in settlement talks. Most civil trials are performed before a jury. Most civil trials are performed before what's known as petite jury, and this is a jury that hears evidence at trial, and this is a jury made up of 12 members. In the jury trial, the judge rules on evidence and judges the jury on a question of law and proper rules of procedure. The petite jury delivers a verdict. Now, the verdict is a decision of whether the defendant should be held liable for the compelled action. A burden of proof, this is on the plaintiff and refers to the obligation that they have in the trial to establish their claims first. A motion for dismissal or a motion for directed verdict, this can be filed by the defendant by the end of the plaintiff's presentation of their case and constitutes a motion claiming that the plaintiff had not established enough evidence to prove their case. If this motion is granted, then the defendant must present evidence, to defend against the plaintiff's claims. Now, deliberation refers to the time in which, after both parties have expressed their case to the jury, the petite jury will retire and decide the outcome of the case. This is deliberation. The preponderance of evidence refers to a statute by which the jury must decide if the plaintiff have proved their case, which means that the evidence has favored the plaintiff's allegations and is stronger than the evidence presented in the contrary. In a civil suit, the plaintiff must prove beyond the preponderance of evidence that the defendant has committed or is liable for the wrong. A hung jury refers to a jury that has yet to render a consensus, and parties, if they are met with a hung jury, must go to a new trial with a different jury. The losing party has the option to file motions for a new trial or for a judgment notwithstanding the verdict, or a judgment NOV. This requires the court to find evidence that does not support the jury's verdict. If the court does make this finding, it will overturn the jury's verdict. The losing party of the trial has the right to an appeal to an appeals court. The two parties are known as the appellant, the party seeking appeals to the decision, or the appellee or respondent, the other party. No trials occur at the appellate level. However, oral arguments will be allowed to be performed or may be presented, and before this is a period before the appellate court delivers their decision. Pardon me again. If the appellant loses their appellate trial, they may seek to bring their trial to the Supreme Court. After that, if the appellant's appeal is denied or the time to bring an appeal expires, the judgment isn't final and known as res judica. Res judica prevents parties from relitigating the same action and renders the decision final. Criminal trials involve no plaintiff, just a defendant, since the crimes are not against one person, rather against the state. This is the plaintiff in this case is replaced by what's known as the prosecution. This is a representative of the state or government that brings the case against the defendant. Now, an indictment is sent from the prosecution to the defendant before the trial, and are written charges to the defendant. This is also sent to the grand jury, which is a group made up of 16 to 23 people, or jurors, who decide whether it is sufficient evidence enough to charge the defendant with a crime. The Fifth Amendment requires that a criminal trial be presented to the grand jury. The grand jury has a broad power to do things like subpoena witnesses and documents. The grand jury decides if there is an accurate and adequate enough evidence to charge the defendant with crimes presented by the prosecution. It will restore the indictment, and a criminal trial will proceed in a similar manner to the civil trial, with the prosecution bearing the burden of truth, or burden of evidence in this case. The Constitution grants that criminal trials do the following. They are speedy, they have a right to a new trial, trial by jury for serious offenses, and they have a right to counsel. In order for a criminal defendant to be found guilty, the petite jury must find that the prosecution established the defendant's guilt beyond a reasonable doubt. If the defendant is found guilty, they can file an appeal for their conviction. Once an appeal has been made, or the time to make an appeal has expired, the defendant may be eligible for a writ of habeas corpus, which is the defendant's request for a new proceeding to determine if they were unlawfully deprived of liberty. This is limited to those who are in custody currently, and is generally made by those who are held in prison who allege that they were unlawfully detained. This may be refused if other resources have been exhausted thus far, and then defendants in the federal court system must bring the writ to federal court, while those in state court may bring it to the state or federal court. Now, talking about jurisdiction, in order for a court to hear a case, they must have both subject matter jurisdiction and personal jurisdiction. Subject matter jurisdiction is the power to decide this case, the power to decide the case, the power to decide the type of case at issue. Federal courts do not have broad subject matter jurisdiction because they can only hear specific cases, and this is known as limited jurisdiction. These are known as limited jurisdiction courts, I should say. A federal court's subject matter jurisdiction results from either one, diversity jurisdiction, which refers to a court's ability to decide cases whether the parties are diverse, meaning that they are opposing parties, are citizens from different states, or are party citizens from a foreign country, and the amount of controversy exceeds $75,000. This is not exclusive and may be heard by either a state or a federal court. They can also grant subject matter jurisdiction from federal question jurisdiction, which refers to the court's power to hear cases arising under the Constitution, federal laws, or U.S. treaties. This is exclusive, and cases involving such questions may only be brought to federal courts. State courts have a broad subject matter jurisdiction to hear any case not reserved extremely for federal courts, making them general jurisdiction courts. Subject matter jurisdiction cannot be waived, and either party can raise a lack of subject matter jurisdiction at any time. And our other type of jurisdiction is personal jurisdiction, which constitutes the power over the particular parties in a case. When a plaintiff brings a case to court, they grant themselves personal jurisdiction over themselves. However, the defendant can establish personal jurisdiction in these ways, unless it constitutes a concern in court. Coming from the 1877 case, Pennoyer v. Neff, it is held that a defendant's physical presence in a state is sufficient to allow the courts within the state to exercise personal jurisdiction over them. A person can also be subject to personal jurisdiction in the state of their permanent residence, known as domicile. As a side note, a corporation has domicile in the state that it is incorporated in. A person can consent to personal jurisdiction by voluntarily appearing in court or agreeing to a court's exercise of jurisdiction. In the 1945 case, International Show v. Washington ruled that if a defendant has a sufficient minimum contact or relationship with the state, then a court within that state can exercise personal jurisdiction over the defendant, even if they have never been to the state. Many states have passed long-arm statutes which allow them to exercise personal jurisdiction over defendants having minimum contacts with their states. This is known as long-arm jurisdiction. Personal jurisdiction may be waived, and if the defendant fails to challenge the personal jurisdiction at the first available opportunity, it will be viewed as waived. Even if both types of jurisdiction are met, the plaintiff's lawsuit must be brought to a court with proper venue. Venue refers to generally represents the geographical limitation on a court's jurisdiction by limiting the courts in which a plaintiff may bring their suit to courts within a specific geographical area where they live or where the events have occurred. Now that has been our second unit covering the American legal system and procedures. This has been Professor Smith, and we will see you next time, part 3, to talk about contracts. Thank you very much.